Okay, so to introduce our guest speaker for today, Judge Tan Ikram. He is the Deputy Senior District Judge, also the Deputy Chief Magistrate of England and Wales. Tan was born and schooled in Slough, Berkshire. He graduated in law from Wolverhampton Polytechnic, is a bencher at Inner Temple, and also admitted as a solicitor. He was elected the president of the London Criminal Court Solicitors Association in 2008. Tan was appointed to the bench in 2003 and to full-time office in 2009. He was appointed the Deputy Senior District Judge, Chief Magistrate in 2017, and is now ticketed to hear extradition and terrorism cases, and was previously an Associate Judge of Her Majesty's Court of Episcopi and Decelia in Cyprus. He is also the Deputy Lead Diversity and Community Relations Judge, one of the editors of the Equal Treatment Bench Book, and a member of the Judiciary's Diversity Committee. He is a contributing editor of Archbold Magistrates Court Criminal Practice 2021 and Archbold Criminal Pleading Evidence and Practice 2021. He's a tutor at the Judicial College and a visiting professor at the University of West London. Well, that's quite an impressive introduction. But Tan Ikram.
I am here.
Fantastic, great.
I was just blushing when you were reading out all that stuff. I don't know what, yeah, anyway. Well, thank you for inviting me to speak this evening. I intend to say some words first and then invite questions, if that's all right. In terms of questions, I can certainly deal with general questions about the process, but not specifics about this particular competition. Can I say this first, that there is a genuine, and I do emphasize genuine, commitment on the part of the Lord Chief Justice and the judiciary to diversifying its ranks. That is a genuine commitment. They are not just words. And I know that because I sit in so many meetings trying to figure out what responses there should be from the judiciary to hasten the diversity of our judges. So these are not just words. And one also has to recognize that recommendations for appointment are not made by judges themselves. We don't recruit judges. The Judicial Appointments Commission they're entirely independent of the judiciary. They have the statutory responsibility for devising the processes by which candidates are assessed. And they have the statutory responsibility to make recommendations to the Lord Chief Justice and the Lord Chancellor on who should be a judge. So the recommendations come from the JAC. They don't come from judges. And I think that's a very important point to start from. That said, where we sit as judges, we recognize that we are not diverse enough. Great progress has been made on many fronts, and we are certainly far more diverse than even when I started in 2003 as a then part-time judge. Is there more work to be done? Yes. Where that responsibility lies is a shared one, and it's a responsibility which we take very seriously. And we do have many schemes, and I know some of them work because I'm involved with them, and I know from personal experience that candidates who, for example, have been on the Law Society program for judicial appointment, it's a free program for BAME solicitors, have been appointed, and they've been appointed to roles as diverse as Deputy High Court Judge, Senior Coroner, and Circuit Judge and District Judge. I know it's true because I can name them. So that there are programs which the judiciary are part of and support through mentoring, through judicial shadowing, through supporting initiatives which are being run, as I say, for example, by the Law Society, that I think has made a difference. It is, however, a very competitive process. And I know that there is a lot of disappointment amongst some who've applied again and again and not been appointed. There can be a variety of reasons why people are not appointed, and there's no single thing that we can put our finger on. But in terms of the immediate reason why I'm here is that I recognize that many lawyers in private practice will be practicing in legally aided practice, in particular as lawyers in private practice dealing with issues such as family law and criminal law. And statistically, we are overrepresented in those parts of the legal profession. And therefore, there is a massive pool out there who I hope would apply for one of the 50 posts that are coming up. As they say, if you don't play the lottery, you can't win. And if you don't put your name forward, then there's no possibility that you can be appointed. But it's not right to say that simply because you are a BAME candidate, and I hope those of you who find that term offensive will forgive me that I am using that term. It seems to be the state of art that's used at the moment. I'm not sure it's entirely appropriate, but it is a short form for describing those of us who are not ethnically white Anglo-Saxon English people. It's the largest competition we've had into the ranks of the deputy district judges in the Magistrates Court. 50 is actually a very large number. So it is one of the biggest recruitment drives we've had, but it is part of a bigger picture where over the last 1 or 2 years, there have been many competitions, many selection exercises, as they're now called, for many different judicial posts. It is an entry-level position. It doesn't require any previous judicial experience. It does, however, require candidates to demonstrate that they meet the competencies which the JAC publish on their website. And if you don't know what it is they are looking for, can I urge you to look on their website to see what those competencies are. The first challenge is to demonstrate to the JAC that we meet those competencies at all. And they look for evidence, and it is an evidence-based assessment. Solicitors and barristers are often not very good at that. We start our careers and we just drift along in our whole career. And unless we apply for a new job in the public service, who are very good at these sort of competence-based frameworks, or we're applying to take silk or something like that, we don't often come across being interviewed and challenged as to whether we meet various competencies. If you go on the website, you'll see them now. And there is an art to filling in the form. And basically, and I run through this very, very briefly, the art in filling in the form is evidencing your behavior, because it's behaviors that they focus on. The idea being that the way you behave now is an indicator of how you would behave as a judge. And they have this model of how a judge might behave. So they're looking from your past, how you have dealt with various issues, and evidence as to how you dealt with those issues becomes, in their eyes, evidence of how you would perform as a judge. So, for example, they will ask you, as one of the competencies, how or your understanding of society and community as a whole, and how you've dealt with that sort of issue in the past. And what they're looking for is, have you thought about it? Have you thought about the diversity of our communities? And tell me an example where you have done it and how you went about doing it. Because it's the how you went about doing it, which is, of course, the way you behave and what the result of it was. There are courses run. I'm not here to encourage anyone to go out and pay for a course, but I draw it to your attention that they're available. You can pay consultants who will give you insights into how to fill in these forms and give you insights as to how they deal with interviews. In terms of our particular selection exercise, it opens in the next couple of weeks, and there'll be 2 stages of tests. Those tests will assess your way of thinking in terms of what I would call judgecraft, how you make decisions in relation to fairness in the courtroom. And of course, you may do that already in other things that you're doing, and I will come back to that in a moment. There will be published the legal background to the test, so it's not completely unseen. We give you an idea of which areas of legislation we will be testing you on. And there'll be a speech or a judgment for you to look at and then answer questions on your understanding of what is said in that speech or judgment. And that's there to test one of the competencies which they look for in good judges, which is the idea that you have to be able to assimilate and clarify information very quickly in a courtroom. So they're really testing that competence by putting you under a bit of time pressure and saying, well, how do you deal with assimilating information when it's thrust in front of you? And those tests will be online. Those who get through the first stage of those tests will then be invited to a second round of tests. The post of Deputy District Judge in the Magistrates Court has a statutory requirement for experience in criminal law and procedure. So we do expect people to have a background in that area of law. And the second stage will assess your application of criminal law and procedure to a set of facts. Because of COVID, all of this is going online. In fact, it's been online for a number of years now, but the final stage is done face-to-face. Now, this year, I don't know whether it will be face-to-face, but it may well be, because it may well be that by the time summer comes, the lockdown that we're in will soften, and we can actually have you in to be assessed face-to-face. And that will be a role play where you will play the judge and be confronted with a courtroom scenario played by actors, and you will be assessed as to how you deal with the various challenges thrown in the role play exercise. And then ultimately there's an interview. So that's a brief outline of the selection process. A deputy district judge is required to sit for 30 days in a year. So you have to make yourself available, and it's a part-time post, and you get paid, I think, I can't remember, £500 or £600 a day while you're sitting. And generally speaking, you will be asked to sit in the region in which you are based. There will be invitations to sit right across the country, because sometimes we face challenges in finding local judges, but generally speaking, you won't be asked to travel far. And you'll be appraised, and you will then be eligible to apply for a full-time post if you want one, and some part-time fee-paid judges decide they don't want to apply for a full-time post. But you can apply after a year as long as you've done 30 days in that year. You will be required to present, I think it is 2 assessors. In Old English, we used to call those referees. They've given them a new title. There's no magic in choosing people with flash titles to be your assessors or referees. They need to be people who know you and they know you well, because they'll be required to also, on an evidence-based basis, give evidence of how you meet those competencies. So they need to know you. They need to have seen you in action. Now, it doesn't mean that each of the assessors or referees needs to be able to speak of all the competencies. Some may be able to talk about your intellectual ability. Others may be able to talk about the way you deal with pressure and you balance lots of things at once, those being some of the competencies that the JAC look for. So it is important to choose your referees properly and carefully, and ensure that they are people who know you. That's the process, and we expect our 50, if we can appoint 50, to be in post by the end of the year. And it's a great job. If you're a practitioner and you also sit as a judge, it really hones in, I think, in your practice, what really works, what levers judges look at, what really matters to the tribunal. And you see lots of skeleton arguments, some which are more effective than others. And that can be really useful because you see lots of other practitioners at work. And I dare say there are occasions when you reflect on your own practice and think, oh, or maybe I'll do it the way she does it, because she does it much better than I've ever done it. But that's about the Deputy District Judge competition this year. It's not the only post you can apply for, and I often say to people, even if you're a criminal practitioner, why don't you apply to become a tribunal judge? Judicial skills are judicial skills are judicial skills. I practiced as a partner in a criminal law firm for many, many years, but my first judicial post was actually dealing with parking tickets. They didn't go down too well with my Legal 500 firm, I have to say. When I broke to the managing partner that I was going to be dealing with people who'd received tickets for parking on 2 yellow lines, he thought I was completely mad, because my day job was dealing with banking frauds and that sort of thing. But it gave me an insight into sort of decision making and how to deal with people. And of course, parking tickets in London is a multi-million-pound business. And local authorities get very, very upset if you rule that the traffic management order doesn't apply in a particular area, or that the light or the signage isn't in conformance with regulation. And you have to give a reasoned judgment. And I worked from that now to being the Deputy Chief Magistrate. And one of my colleagues, Gary Hickenbottom, also sat as a parking adjudicator. And some of you will now know him as Lord Justice Hickenbottom. What a climb he's had from dealing with single yellow lines to now being a Lord Justice of Appeal. So it doesn't really matter where you start. You can meander through the different ranks and the different areas of being a judge. And in fact, the majority of positions are in the tribunals. That's not for 1 second suggesting you go for a tribunal post, because why shouldn't you apply for recorder if that's what you really want to do? That's all I want to say by way of introduction. I could talk for hours, and of course we're all very good at that in this room, because we do that for a living. But I think you can only bear me for a limited period. Perhaps it may be easier to deal with this as a conversation, and see where we go.
Fantastic, thanks, Tan. We've got some questions in the chat already, and for those that have put questions in the chat, you're more than welcome to ask the questions yourself if you want to. So if you do, just put your hand up and unmute yourself, you can ask the question. The first one we've got in the chat is from Shahido. Shahido, are you there? Do you want to ask the question yourself, or do you want me to read it out?
Do you know one of
Hi. Sorry, would you mind reading it out? Only because I'm multitasking at the moment with my son. So,
of course,
I'll tell you one of the things about COVID is I spend hours talking to myself, whether it be virtual hearings on live links, or whether it be all the Zoom meetings that I do, and it is a sign of madness, you know, when you start talking to yourself.
Thanks for that, Tan. So Shahida says, salams, Tan, and thank you, AML. Just a question from me. If the Lord Chancellor is so keen to increase diversity, then what do you think is holding back Asians from attaining those positions?
What is it that's holding back Asians from attaining those positions? I think there's a multitude of reasons, and I am not a sociologist or I don't know what field you'd have to be an expert in to definitively answer that question. From what I can see, the answer is I don't know. If I did know the answer to that question, and if we knew the answer to that question, believe me, we would try to deal with it head on. Ethnic minority candidates drop out at all stages of the selection exercise. Some will not get through the test, some will not get through the second test, some will be filtered out in the role play, and some will be filtered out in the interview itself. I have some theories, and I'll share some of the theories with you, and you can poo-poo them and say I don't agree with you. I think one of the disadvantages we have, and it is a disadvantage, is that we're not linked into those networks, which some people have. And some people naturally are in the sort of cliquey groups where they're surrounded by judges, where it's normal. And there's a word which I use, which is very old-fashioned now, and I'm not sure necessarily appropriate. I use the word groomed. Now, groomed has taken this horrible meaning over the last few years. I call it grooming by sort of mentor and support and sponsorship. And I give an occasional lecture at Eton College. And if any of you have been to Eton, it's a wonderful place, and I'm not going to knock it at all. But I suspect not many in this room have been to Eton. And I never, I mean, I wish I'd gone to Eton, right? Because if I had, I think life would have been easier for me in my career, but I didn't. And the reason why I say life would have been easier is that when I've met these sort of 14, 15-year-olds, they ask the most profound questions. Like, do you think pupillage at 2 King's Bench Walk is a good idea if you want to do, you know, family public law? And you're thinking, how did you as a 14-year-old need to know how to ask that sort of question? And it's a reminder that some people throughout their childhood and career have a lot more support, mentoring, because of their natural circles. And I think we can be disadvantaged by being outsiders. And just being an outsider, whether it's based on ethnicity, whether it's based on class, whether it's based on so many different variables, means that they end up as having a head start. And I think a lot of us have that intersection, don't we? We have our ethnicity. We also have our sort of socioeconomic roots as well, because we're more likely to be from working class backgrounds. And there's a lot of evidence that class also has a lot to do with career attainment, etc., etc. And when you start bringing all those factors in, you know, our class, maybe that we didn't go to the top universities, and certainly in my generation, and of course I am old, I'm not like some of you kids, if I may say so. You know, I was born in the early 60s. I went to Polytechnic in the 1980s. And in those days, you know, our parents could barely speak English. They'd come to the country. They didn't have any networks in this country. They gave us little guidance and little real insight. We didn't have much careers advice in those days. You know, people my generation had no idea how to break into these things. And I know it's changing. I know it's changing. The fact we're having this conversation even at all, the fact that there are words like diversity being bounded round, and initiatives such as the shadowing scheme, mean that we can actually bridge some of those gaps so that we can bring people up to the starting line and give everyone an equal opportunity to compete in what is a very, very competitive process. I don't know whether there's any evidence at all that the processes are institutionally biased. I'm not an expert in process. And I mean, I could not accept that we are any less able to sit a test than anyone else. So those sort of aspects which people say, oh, well, the process is biased against us. Well, my answer to that is I've got BAME judges sitting at every stage of the process. They're involved in the setting of the papers. They're set in the marking of the papers. They are part of the team that will actually be doing the face-to-face interviews. And they have had training. And of course, they have insights into difference and how that can impact. So we're doing all we can, but I accept that the results haven't been as fast moving as they should have been. Sorry to ramble on so long, but it's not a simple question.
No, it's not. And I'm going to come in there a bit if I can. But you mentioned, obviously, when you started out and being in that position and you found barriers, was there ever a time where you thought, you know what, my uniqueness, the fact that I'm different in my background, that's actually something that I'm going to use to my advantage?
Well, certainly when I went to the British sovereign base area in Cyprus, I think it helped. I mean, I was a judge in a British overseas territory. And, you know, the last thing they expected was a brown guy turning up from London. They expected some old white man, I suspect, from London, as a sort of stereotypic English judge serving in one of the British overseas territories. But the fact that I really understood what culture means and difference in culture and how that impacts on simple things like urgency to do things, you know, because Cyprus has got a rather South Asian attitude to getting things done. It's all, you know, we'll get around to it, and no sort of urgency at all. And sort of the idea that here I am applying a form of colonial law, or certainly law which has colonial history, over a population which is Greek or Turkish Cypriot. How does that feel? And I think, again, my ethnicity, my cultural background was probably something I could actually use during the course of my interview to actually give assurance to the panels that I would be sensitive to those sorts of issues. So yes, I think your difference is something which is something the judiciary is positively looking for, and something you can use.
Great. We have a question from Ikram who says, would you recommend shadowing, even though it's not a prerequisite?
Yes, I mean, look, there's several schemes. There's a judicial shadowing scheme. You can go through the judicial office who run the scheme, just Google them. You can do informal shadowing, and if any of you want to do some shadowing, just to email me and we can try to sort something out informally if you can't get onto the formal scheme, okay? We've got something called the PAGE program, that's P-A-J-E, which is the pre-application judicial education program, which gives you insights as to how judges work and what being a judge really means. And that, I think, is also an insight. It goes back to the point I made earlier, which is we don't really know lots of judges, and if we do know them, we know them quite remotely. We don't socialize with them, and they're not part of our circles. I dare say we've got some members of the bar here. The bar seem to be a lot closer to the judiciary than the solicitors, because former members of chambers tend to sort of be linked in still to their processes and keep contacts with their chambers. And perhaps they have an advantage even in that. So the answer is yes, go on the judicial shadowing scheme. We also have a judicial mentoring scheme, which is set up specifically for BAME lawyers, and you'll be paired up with a mentor who again will support you as to what do you need to do, how you're progressing, what other things you can do so that you are ready to be a strong candidate for judicial appointment. And as I say, there are some paid for courses. I'm not recommending them. I'm not here to sell anything, but they're out there and people use them.
Thank you. Next question is from Ibrahim Ilyas. Did you want to ask your question, Ibrahim, or did you want me to read it out?
I'm happy with asking it, thank you. Hi, Tan. My question is, what advice would you give to myself, an incoming people barrister, in terms of having it in my mind that I'd like to ultimately join the judiciary?
Which uni are you a member of?
Middle Temple.
Oh, never mind. At Inner, we actually have a judicial shadowing scheme in pupillage. Yep. So you can, at Inner Temple, you can apply through the Inn as a student to do some marshalling with a judge. I don't know whether Middle Temple does the same.
Yeah, I've done marshalling.
Fine. Well, I think that gives you a really, really interesting insight into how the judge's eyes work, what perspective they're looking for. And then I think it's to be as good a lawyer as you can be. If you have strong assessments in relation to the competencies and you can evidence strongly what they're looking for, and you are aware early on in your career that you've got to build up a portfolio of evidence and support, then you can do some career planning. I was a governor at a school before I applied. I was doing training for lawyers. I was presenting CPD training courses. And, I was able to argue that I kept up to date, for example, not by reading or going on courses, but by presenting the courses. Now, beat that. And so, there are career things you can do to be the strongest candidate in the group. And that's something you can start thinking about now, so that you can build up to an application where you've already thought very, very carefully, how will I evidence this? Yeah. So you can go to most local authorities, they have panels on schools admissions, and you can make decisions about whether kids have got into their first school of choice. Some of you could apply if you wanted to become lay magistrates. What I'm saying is you might strengthen your application by having strong evidence before your first application. And a lot of the good candidates are doing that. So whilst I'm saying there's no requirement for any judicial experience, having examples of where you have to make evidence-based decisions already in your career is very good evidence. I mean, you might be a Crown prosecutor making decisions on whether to bring charges. You could be a local authority lawyer. You could be exercising judgment in some other way as a trustee of a charity. But you see how you've got to think laterally on how you're going to say, yeah, I'd be really good at making decisions because I take into account all the relevant factors and I believe in fairness and giving people an opportunity to speak and all those sorts of things. So the answer is, think about that now, not the day you're going to apply. And you only have to have 5 years experience as a practicing barrister before you can apply. Now, it's very difficult to get into that 5 years, but I mean, we've certainly got one full-time judge in her 30s, which I think is incredible.
Yes, I was just going to say it's a bit of a coincidence. I am a magistrate. I sit at Birmingham.
Ah!
And you're probably referring to Bryony Clark.
I am.
Yes, yes, I know
And
Bryony.
she's so young.
It is very much.
She's so young. And, you know, I'm an old man, but, you know, they are getting younger. And so, you know, people who career plan, if I can use that word, and think very, very carefully about, you know, how am I going to put this portfolio of evidence together and think about it, I think are in a stronger position than people who say, oh, the competition opens Monday, I'll try to fill in the form.
Thank you very much.
Pleasure.
Thanks, Ibrahim. Thanks, Tan. I think that also covered Adal's question as well, that he's also a barrister in his first year out of pupillage. So I think you just covered that. Now, the next question is from Shafi.
Tan, hi, thank you very much. I just wanted to ask, you were talking about the tests and you mentioned background expertise in criminal law. I just wanted to ask to what extent a background in criminal law was necessary or relevant for these positions.
Well, it's a statutory requirement. You've got to know, you've got to have a background. If you don't have a background in criminal law procedure, you could be an academic, you could be a local authority, you could be working for the SFO, CPS, defence, or you might have had a mixed practice where you did some crime. It's not a massive, you know, you don't have to be the world's expert in criminal law, but you've just got to have a background in it.
Okay, thank you.
But there is going to be a test, and you will have to compete with people who may do it more than you. And in a competitive process, the people who get the top marks are going to go on to the next round.
But if, for example, you've been in a commercial context for the entirety of your career?
Well, then you won't meet the statutory criteria for Deputy District Judge in the Magistrates Court.
Okay, that's fine, thank you.
But are there other, but Tan, there are other positions, as you mentioned, on the JSC website, right?
Yeah. I mean, you might want to become a Deputy High Court Judge, and you could apply for the PAGE programme if you wanted. There's a judicial shadowing scheme to sit as a Deputy High Court Judge, and you could apply simply to go straight to the Deputy High Court, to the High Court. You could apply to become a tribunal judge.
Yeah, okay, thank you.
Horses for courses. Not all of us want to be criminal judges.
Yes, no, that's fine, thank you.
Thanks, Shafi. Next question we've got is from Harminder. Harminder, did you want to ask the question?
Good evening, sir. Thank you for speaking to us firstly. I do have a question. You mentioned, are you able to hear me properly?
I can hear you perfectly.
Lovely. Okay, I had a conference earlier, it wasn't clear. So you mentioned the fact that the JAC process, especially the early application, it's quite geared towards like a civil service corporate application. I'm a criminal practitioner and I've worked in legal aid for 10 years. The JAC obviously seem to be aware that legal aid practitioners aren't necessarily geared towards completing these type of applications. And also the fact that ethnic minorities are overrepresented in the legal aid sectors. Is the JAC going to do anything to actually amend this disparity?
The sorts of processes they're using is what a lot of progressive employers are using, even in private practice now. You're very young. You know, when I came into the legal profession, it was a sort of 15-minute chat with the managing partner, and that was about it. And you'd suddenly have a career right up to equity partner on the basis of the equity, the managing partner liked you, you know. But you know, if you apply for a training contract with one of these sort of HR orientated law firms today, they're using the same sorts of tools. They're all looking at competencies.
Well, I think my youthful looks may be deceiving, but I've never actually had a formal application or interview process in the last 10 years of being a qualified solicitor.
Yeah, I know.
So,
yeah, I kind of recognise that point in my address, that a lot of us are just not used to this, because we join a law firm and then we knock around and we become a senior associate and then a salaried partner and a partner. And we never really apply for another job.
no.
Or if we do, it's from a rival firm who poaches us on a sort of slightly informal basis.
Absolutely.
And that's how it works. It's a real challenge. And I know that, you know, some of the civil service lawyers are in an environment where they're being appraised. We don't get appraised as practitioners. We just trying to get the next client.
Yeah.
And they do 360 reviews, and for promotion, it's all based on evidencing their competencies. And so they have an insight. We don't, as solicitors in private practice. So the answer is we have to familiarize ourselves. And the JAC do roadshows. COVID has completely kind of ruined all that. But I mean, I've over the years done many roadshows with the JAC where they've gone out to Birmingham and been up to Leeds and all sorts of places where we've spoken to lawyers, and the JAC, for example, as part of a panel, have given an insight into the selection process. Right now, the way to do it is to go on the PAGE program. It's an online thing mostly, and it's a load of videos, including me, of course. And you just listen to a load of judges talking about different jurisdictions and what sort of works and what doesn't work. Or, as I say, go through mentoring or judicial shadowing where you can get an insight into the selection process. But most importantly, go and look at a form, and then follow this idea. It's called the STAR system: situation, task, action, result. You describe the situation, what the task you had to do. The key bit is the action. And you've got to sort of look at barriers and you know, to getting it done, and how you got it done and what the result was. And if you follow that sort of process in the selection process, you stand a much better chance. Oh, your voice is not there at the moment.
Oh, apologies. I said thank you for your time this evening.
It's a pleasure.
Thanks for the question, Harminder. And yeah, I'll reiterate, STAR is a godsend. And so if you just Google on the internet STAR and competency-based questions, I mean, that's what I've used over the years, and you get some really, really good ideas on that front. I can see that Khalid has his hand up. Khalid, do you want to ask your question?
Yes, thank you. I just want a question to in regards to judges' presentations. You mentioned that in terms of the process that you can, no, you're not sure about that the process is institutionally biased. But in terms of your experience within the judiciary, how do you feel personally about the institutionally biased in terms of BME or other in progression as well? How do you feel about these things? And do you have any personal experience that you can share to understand the actual inside of the judiciary?
I can only share my personal experience, and I'm not saying everyone will have the experience I have had. But I mean, you know, I've got a 2-2 from Wolverhampton Poly. I haven't got the grandest education. I passed my bar on the reset. I was a legal aid high street solicitor. That's what I was. And now I'm the Deputy Chief Magistrate of England and Wales. I'm paid rather well. I have a senior leadership role amongst my rank. I haven't felt, while I've been in the judiciary, that I've been held back because of my ethnicity. If anything, I've heard people turn to me a lot, asking for advice on how to deal with things. So I can't say that I have personally experienced any bias in the system which has prevented me from progressing. But I would say that because of the privilege of sitting here and addressing you today. Others, you know, I can't speak for other people's experiences.
Thank you.
Thanks, Tan. I have a question here which has come to me directly. Can you please mention the 3 most important professional skills you think are needed to succeed in the application process and how to achieve those.
Blimey, that's a tough one. It's like an exam question in itself, isn't it? The 3 most important qualities.
Skills, yeah, skills, qualities.
Yeah. Well, the first is to be able to understand an application form, because if you don't understand the application form, you're not going to get past first stage. Secondly, and that does mean an awareness of STAR. I mean, really, that is central, because if you don't get your application form right, you're going to fall, even if you get through all the selection exercises, also the tests, because they're going to say you don't meet the competencies that they're looking for in the candidate. So you've really got to understand what they're looking for. So first quality is spending time and investing in understanding the process. The second is being able to understand the law, because if you don't get past those selection tests, you won't get to the role play. And that's where most candidates, if you think of it statistically, are weeded out. I don't know how many applicants we will have, but I mean, most of those applicants will never, ever see the role play or interview. They're going to be eliminated simply on those tests. So those who have invested time reading the pre-reading which you are given in advance and doing it properly are going to have an advantage. So there is some advantage in those people who are good at doing tests and exams, and that's a technique issue. Third, certainly for my jurisdiction, of course I need to know law, but any of you who've got any experience in the Magistrates Court right now will know that the biggest challenge and the biggest skill that any judge can have is how do you wade through treacle, which is waist high, and nothing seems to be quite in the right place at the right time. And how do you find solutions to all the obstacles? Reports not being ready, CVP not working, lawyers absent, papers not being filed on time, directions not complied with, disclosure issues, and witnesses that are unavailable. And you've got to find solutions to all these things to keep the system going, because one of the big pressures, as you will probably know, is the delay that there is in the system at the moment. And that comes, I think, of being a competent practitioner and being good at what you do. So the other final quality is do what you do right now very well.
Good tips, thank you. There is a question that's come to me about where we can find more information regarding the shadowing opportunities that you mentioned and the training. Would you be able to send me some links afterwards, Tan, and I can share them?
Google Judicial Office Judicial Shadowing Scheme. It'll come up. There are other browsers and search engines. It's not just Google.
Excellent, thank you. And we have, I think, we've got one more question here. If you are unsuccessful at any stage, is there any feedback given to you, if any, so that you can sort of improve next time around?
Yeah, you can ask the Judicial Appointments Commission for formal feedback on your application, and they will give you some feedback on how you did and where you fell down. So yes, there is a formal feedback mechanism for unsuccessful candidates.
Fantastic, that's good to know. Do we have any further questions at all from anyone?
Don't be shy.
Looks like we don't have any more. Tan, I think you're off the hook.
I have one question.
Oh, here we go.
A question about faith commitments. How is that accommodating the judiciary in terms of prayer, fasting, etc.?
Well, there's the Equal Treatment Bench Book, which is available to all of you to have a read. It is a book written by judges for judges on exactly issues such as that. So if you read the chapter on religion, it will give advice to judges. And I think the advice to judges on the 2 specifics are, if a lawyer or a witness or a defendant wants to read their namaz on Jummah, then you make allowance for that. And if you're during Ramadan, then you avoid trials where witnesses will have to give evidence and they're not eating and drinking. That's the advice that's given to judges. And you can point to the equal treatment bench book in a courtroom if you are facing those issues and you find that somebody perhaps isn't as sensitive as you would hope they were to the issue, because you can say, you know, Your Honour, or whatever, can I just refer you to the Equal Treatment Bench Book, which is guidance written for the judiciary on how to handle these sorts of situations.
I hope that answers your question, Ibrahim. We've now got another couple that have come up. Shahidu, do you want to ask your question, or shall I ask it? I'll ask it for him.
I'm happy for you to ask that.
Okay.
Thanks.
Judges must be seen to be independent and impartial, and I'm mindful that social media can have an impact on that. Does the JAC consider an applicant's social media history during the application process? I think that's a very good question.
You'd have to ask the JAC that, but judgment is a very, very important part of the job. Full-time salary judges cannot do politics in public because of the separation of powers. But that doesn't prevent you having a political past prior to you coming into the judiciary. I mean, the reality is, if you lack judgment and you put silly posts up and you get found out, that's going to call seriously into doubt whether you have the correct temperament and judgment to sit on judgment of others. Whether it's part of the formal process, I have no idea. I honestly don't know. It wouldn't surprise me. It wouldn't surprise me, but you are actually asked the question on the application form, is there anything we need to know about you which might cause embarrassment to the judiciary? And if you don't answer that question and they find that you didn't answer the question frankly, that goes to your judgment again, doesn't it? So, I mean, if you've said something stupid, you know, I have to say I'm very lucky because I'm old. You know, when I were a kid, we didn't have Facebook and Instagram and all these things. So luckily I've escaped that generation where you kids, or as on Scooby-Doo they would say, you meddling kids, are all on Facebook and Instagram and all these other strange places where they make strange comments. We didn't have that, but I think you have to be very careful, because don't also forget another very important point, which is that what if you were sitting in a trial and someone found something? And I'll tell you, defendants do look. Lawyers do look you up before they come into the courtroom. And defendants and witnesses, well, the witnesses won't know. But I mean, I think defendants often find out what judge will be sitting because their lawyers sometimes try to find out, or they just find out. How embarrassing would it be if you were a judge and you'd said something very, very silly and inappropriate on social media? I think, well, it clearly is an important reflection of your public persona, and I think people should be extremely cautious in what they say publicly.
Okay, another couple of questions have come up, and this is from someone that does commercial law. What if you do a commercial area? I know that a MAGS district judge isn't appropriate, but how does the High Court deputy judge scheme differ, if you know?
Yeah, the answer is that the selection exercise test will be geared in a very different direction, more in tune with the sort of practice area jurisdiction. The emphasis on skills may be different. In the High Court, they may not be as interested, for example, at working at speed. It's just an example. I'm not saying it's necessarily so, but the way you practice may be more in tune with how a High Court judge operates in their arena. So the selection process will be skewed in terms of the competencies they think are really, really important in that jurisdiction compared to what I think is really, really important for my team, which is working under pressure, having high volumes of work, and having to know the law themselves, because we deal with loads and loads and loads of litigants in person. Whereas, for example, the Court of Appeal, or certainly the Deputy High Court judge position, may be less reliant on those skills of litigant in person, though of course litigants in person are now becoming the norm everywhere, so that isn't actually necessarily so. So what you'll find is that what they're looking for in their candidates are slightly different than what we may be looking for.
Okay, final question, Tan. I'm sure you're eager to go and watch Boris Johnson at 7. The question is from Mohammed, and it says, it appears to me that the role is only for those lawyers who have brilliant achievements throughout their career. Please correct me if I'm wrong.
I don't agree with brilliant achievements, but what I do say is it is a competitive process. And in any competitive process, those people who can demonstrate with the strongest evidence their alignment with those competencies are going to be successful. So strong examples may come from those people who've been more thoughtful in relation to how they evidence them. That does not necessarily mean you have to be a brilliant high-class lawyer. I mean, some brilliant lawyers make really bad judges. In fact, it's often said that brilliant lawyers sort of enter the arena perhaps too much. On the other hand, someone who has really, really good judgment, has kept themselves up to date in the law, is really familiar with the challenges of society around them, takes an interest, self-develops, and juggles all those different things at once because they're a single mother, and they have to deal with all those challenges at the same time, may actually meet the competencies more closely than a QC. Because nowhere in the competencies does it say you have to be a brilliant lawyer. It doesn't ever say, please now show me why you're a brilliant lawyer. That's not a question that's ever asked. So I don't agree with that description, no.
One other question has snuck in, if you've got the time. It's quite an interesting one, but it's about how you deal with frustrations in the public sector and court process, because it's no secret that courts are understaffed and underfunded, and obviously it's very different to working in private practice.
Keeping calm is the important thing. You have to do the best you can with the tools that you have. And you have to find solutions within the limitations of the resources there are. You can't throw your weight around and get things done which are just not going to happen, because there just isn't the money, the infrastructure, the resource, the time to do it in a particular way. So I think you deal with the frustrations by first understanding the limitations, secondly by having patience, and being realistic about what you can and cannot do, but most importantly finding those solutions. And sometimes it can be very, very simple solutions, just using imagination rather than being necessarily a lawyer. A lot of common sense comes into it. Yeah.
Thank you. Thank you, Tan. Thank you on behalf of all our attendees today, on behalf of the Association of Muslim Lawyers, for joining us. It's been a really interesting session, and I sincerely hope to see a lot of you that are on the call now sitting on the bench in the not too distant future. Thank you, Tan.
Take care.